Companies Act, Section 102, Statement to be annexed to notice. Section 102 of the Companies Act plays a crucial role in ensuring transparency and accountability in the decision-making process of companies. It mandates that a statement of material facts be annexed to the notice calling a general meeting, especially when the agenda includes special business. This ensures that members are fully informed about the nature and implications of the matters being discussed and voted upon, particularly when these matters involve the interests of the company's directors, key managerial personnel, KMP, or their relatives. The section establishes clear guidelines for disclosing financial and other relevant interests, thereby promoting good governance and preventing conflicts of interest. Below is a detailed breakdown of Section 102, focusing on the requirements for special business, the disclosure of material facts, and the consequences of non-compliance. Subsection 1. Material facts to be disclosed. 1. Nature of concern or interest. When a general meeting includes items of special business which are matters requiring approval or discussion that fall outside the scope of routine business, a statement of material facts must be annexed to the notice calling the meeting. This statement is intended to provide transparency about the business items on the agenda and help members understand the implications of each item. The statement must disclose the following material facts concerning each item of special business. A. Financial or other interests. The statement should specify the nature of any concern or interest, financial or otherwise, that directors, managers, and key managerial personnel, KMP, may have in respect of each item of special business. This includes directors, any financial interest or relationship with the company that may influence the director's decision on the matter. Managers, if any. The same disclosure requirement applies to the manager, if one is appointed. Key managerial personnel, KMP. This includes the company's other senior executives, such as the Chief Financial Officer, CFO, or Company Secretary, and any financial or personal interest they may have in the special business. Relatives. The statement should also include information about the interests of relatives of the persons mentioned above, as these relationships may affect decision-making and voting at the meeting. B. Additional information to aid decision-making. The statement must also provide any other information or facts that will help members understand the meaning, scope, and potential implications of the business to be transacted. This might include a detailed explanation of the rationale behind the proposal, potential outcomes, and the impact of the decisions on the company and its stakeholders. The goal is to ensure that members are fully informed before casting their vote on any special business items, reducing the likelihood of uninformed decision-making or conflicts of interest. Subsection 2. Special business in annual and other meetings. 1. What constitutes special business? In the context of annual general meetings, AGMs, and extraordinary general meetings, EGMs, different types of business may be classified as special, requiring disclosure of material facts. A. Annual general meeting, AGM. In an AGM, all business transacted is deemed to be special business, except for the following items, which are considered ordinary business. Consideration of financial statements, the review and approval of the company's annual accounts, including the balance sheet and profit and loss statement, are routine and not classified as special business. Report of the Board of Directors and Auditors. The presentation of the Board's report and the Auditor's report is a routine matter. Declaration of dividends. The decision to declare a dividend is considered a regular, routine matter. Appointment of retiring directors. The reappointment of directors who are retiring by rotation is considered ordinary business. Appointment of auditors and fixing of their remuneration. The appointment of auditors and the determination of their remuneration are also considered ordinary matters. B. Extraordinary General Meeting, EGM. In contrast, all items of business discussed at an EGM are automatically considered special business because these meetings are typically called to address specific, urgent matters that require the approval of members. See disclosure related to other companies. If any special business pertains to or affects another company, example a merger, acquisition, or investment in another company, the disclosure requirements extend to the shareholding interests of key individuals in that other company. Specifically, if the shareholding of any promoter, director, manager, or key managerial personnel of the first company in the second company exceeds 2% of the paid-up share capital of the second company, this shareholding must be disclosed. This ensures that the members are aware of any potential conflicts of interest or personal stakes that might influence the decision-making process. Subsection 3. Reference to documents for inspection. 1. Document inspection at the meeting. If any item of special business refers to a document, such as a contract, agreement, or financial statement, that will be considered during the meeting, the statement annexed to the notice must specify the time and place where such a document can be inspected before the meeting. This ensures transparency and gives members an opportunity to review the relevant documents before casting their votes. Subsection 4. Consequences of non-disclosure or insufficient disclosure. 1. Holding of benefits in trust. If a promoter, director, manager, or key managerial personnel fails to disclose material facts or provides insufficient disclosure, resulting in an undisclosed benefit to themselves or their relatives, either directly or indirectly, that individual is required to hold such benefit in trust for the company. A. Obligation to compensate the company. In addition to any other legal action that may be taken against the individual for breaching the provisions of the Companies Act or other applicable laws, the individual will be liable to compensate the company for the benefit they have received. The compensation must be equivalent to the amount of the benefit derived from the non-disclosure or insufficient disclosure. This provision acts as a deterrent to ensure that all stakeholders act with integrity and transparency, safeguarding the interests of the company and its members. Subsection 5. Penalties for non-compliance. 1. Penalty for default. Failure to comply with the provisions of Section 102, especially the requirement for full disclosure in relation to special business, can result in significant penalties. If a promoter, director, manager, or key managerial personnel is in default, they will be liable to a penalty of 50,000 rupees, or 5 times the amount of the benefit that the individual or their relatives have accrued from the failure to disclose, whichever is higher. This penalty underscores the importance of complying with the transparency requirements set forth in the Companies Act and serves as an incentive to ensure that companies and their officers act responsibly in disclosing material facts during general meetings. For more details, contact us.